Hi, my name is Tiffany Dowell Lashmet. I'm an extension agricultural law specialist with Texas A&M. I'm based at our district research and extension center in Amarillo, but I have statewide responsibilities, and so I normally travel around the state giving presentations to various landowners and agricultural producers about important issues of agricultural law. And so I really appreciate the opportunity to be here to present today on behalf of the Texas Wildlife Virtual Education Seminar. And I'm excited to talk to you about the topic of landowner liability. So when I speak, I have to give a little disclaimer. Basically, it just says, I am a lawyer, I'm not your lawyer. So I'm happy to give some general information, but nothing that I present today should be construed as specific legal advice. The other thing that I will offer is if anyone has questions after today's presentation, you can feel free to contact me and I'll be more than happy to try and answer those for you. I'll make sure and include all of my contact information on the last slide. So with that, let's get started. And what we're going to talk about today, like I say, is a topic of landowner liability. It's a very important topic and one that I think is easily overlooked by Texas landowners. And so I've put together kind of a list that's 5 steps to liability protection. So if you're someone who owns, leases, or otherwise operates land, these are just 5 steps that you can take to really help alleviate the potential risk of liability if somebody comes on your property and gets injured. Due to time constraints, we're not going to walk through all 5 of these today. Normally it takes me about an hour and a half or 2 hours to cover all of these topics. But today I've pulled out the 3 that I think are the most important. So we're going to look at each one of those 3 items, and then we're also going to briefly discuss a recent Texas Supreme Court case dealing with landowner liability as well. So the first step to landowner liability protection is to have liability insurance. If you're not going to do anything else that I recommend today, this is the one that you want to do. And liability insurance is something that any landowner in Texas needs to have. It's also something that any agricultural tenant needs. So if you're someone who maybe is leasing land for grazing, or if you're leasing land for growing crops, you as the tenant also need to have liability insurance to protect yourself. Liability insurance is usually pretty affordable. Now you may say, wait a minute, I saw our insurance bill last year and that was expensive. But truthfully, if you looked at that bill in detail, they'll break it out into what's the cost for property insurance coverage and what's the cost for liability coverage. The liability is usually a fraction of the property insurance price. Just by way of example, we've got some land here in the Texas Panhandle. We've got liability insurance on there. I think it's $500,000 policy on that property. Guess what you think that costs every year to have a $500,000 liability insurance policy? It costs right around $100. And so super cheap money, right, for the benefits you get from having insurance. And so let's take just a minute and talk about what those benefits are. I think everybody understands the idea of insurance and knows that one benefit is if an injury occurs and it's a covered claim, the insurance company will pay up to the policy limits on any sort of claim. The other major benefit of insurance that you don't want to overlook is that liability insurance provides you a defense if some claim arises. So on that property I mentioned that we own, if somebody gets injured, my first phone call is going to be to my liability insurance company. They're going to hire me an attorney on their dime to defend me and get me out of that case. So the idea that for, a couple $100, you can have, insurance coverage as well as like a lawyer essentially on retainer, that's really money well spent. So keep that in mind when you're thinking about insurance policies. How much coverage do you need? I'm going to give you the super unhelpful lawyer answer and tell you it just depends on what you're doing. It depends on the amount of risk you have related to that land. So I sort of like to think about it like a totem pole, right? And we've got the property I mentioned. It's in the middle of nowhere. We only run cattle on there. It's not on a major highway. or road. We don't have hunters, we don't have other people out there. It's just not super high risk. And so we have insurance, but we're lower on that totem pole. Last summer, I took my kids, or last fall, rather, I took my kids to a pumpkin patch, and it was great. All I could see were liability pitfalls everywhere I looked, right? You have little kids running around out in a pasture with weeds and bugs and snakes and scissors and who knows. They're going to need a lot more liability insurance than I need, right? They're much higher on that totem pole. And that's where working with a good insurance agent who understands agriculture and who can really help advise you on how much coverage you should be looking at can be really helpful. I usually say to people, I really don't care who you have insurance with. I really don't care if your policy is called a farm and ranch policy or a homeowner's policy if it covers what you need covered, or a commercial farm and ranch policy. It doesn't matter. As long as the coverage is right, the title I don't care that much about. The one tip I would give you here is if you're going to have people on your property for recreational purposes, that's going to be things like hunting, fishing, hiking, biking, riding four-wheelers, nature photography. If you're going to have those kind of guests on the property, you should consider having the amount of coverage listed in the Texas Recreational Use Statute. We're going to talk about that statute in just a couple of minutes. And if you have that level of coverage or higher that's listed in the statute, you get some added benefits because of that statute. So just keep that in mind when we get to that point. Okay, so that's the one baseline I'll give you. If you're going to have recreational users, I will give you a number that you should at least have that much. Otherwise, it really just kind of depends. Another thing to look at with liability insurance is to make sure that every activity you have going on is covered by the insurance. So, if you've got land and you're just running cows and you've got a farm and ranch policy that covers that, you're great. You want to make sure everything is covered. So what if those cows get out and end up on the road and get hit by a car? Is there coverage for that included in the policy? You want to double check. What if you decide to start, open up like a roadside stand where you're going to sell the vegetables from your garden next to the pasture where the cattle are? Now, does your insurance policy cover you for that? You better check, right? So anytime you're doing something that's different or new, always a good idea to make sure it's covered by that liability insurance policy. Another thing to be aware of with liability insurance is that you want to watch for caps on coverage that sometimes pop up in the fine print. One place that I see this are policies related to spray drift damage. So let's say that you've got $1 million farm and ranch policy. I have seen kind of in the fine print where there will be a cap on coverage for damages related to pesticide drift, and they cap that at like $25,000 or $50,000. There's a big difference, right, between $1 million and 25 or 50,000, and you need to make sure you're aware if those kind of caps exist. Usually if they do exist and that's a concern for you, you could buy additional coverage for an additional fee from your insurance company, but that's certainly something to be aware of and look into. Okay, so that's the first thing, liability insurance. Like I say, everybody needs to have that type of coverage. So if you don't take anything else away today, I hope that you make sure you've got your coverage, you review your policy, make sure you're happy with it. It's the levels that you think you need. It covers every activity going on. That's just really, really important. Okay, the next topic let's talk about is the use of liability waivers, or sometimes they're called liability releases, same thing. I will get the question sometimes, well, are those liability waivers even worth the paper that they're written on? At least in Texas, the answer is courts generally will enforce a liability waiver if it's properly drafted and if the injured party is an adult. So we're going to talk about those here in just a minute. But again, the general answer is courts will enforce them, but you've got to make sure all the T's are crossed, the I's are dotted correctly to make sure that those are enforceable. You'll notice here I said that they're enforceable generally if the injured party is an adult. The reason I say that, is there is some question in Texas law as to whether courts will enforce a liability waiver if it's been signed by a parent on behalf of a minor child. So if I'm a parent, I have a child under the age of 18, if I sign a liability waiver on behalf of the child, there's at least one appellate court decision and a couple of federal court decisions looking at Texas law that say courts will not enforce those. It's kind of on public policy grounds. They don't want to leave injured children without remedy. The Texas Supreme Court hasn't ruled on that. So I don't think it's a completely settled question of Texas law, but I do think it's an area that you need to be aware of and be at least a little bit concerned about as you're looking at these waivers. That said, I personally still do have parents sign waivers on behalf of minor children because, like I say, until the Texas Supreme Court makes that ruling, they might be enforceable. So I go ahead, get the waiver, have the parent sign on behalf of the child. I just know in the back of my head, this may or may not be enforceable. And we'll talk in a minute about a couple of other defenses that would likely be enforceable under certain situations, even if this waiver is not. And so that's one thing I will say when we're looking at these 5 steps to liability protection. Keep in mind, my goal is to give you kind of a defense folder where you're going to have all of these different potential weapons in this folder that your defense lawyer can use to help get you out of a lawsuit. You only need one to work, right? The kicker is we just don't know which one that might be, and that's why having all the options in the folder can be so important. On liability waivers, listen, there are things in the law that you can probably do yourself. Drafting a liability waiver is an area where I would use an attorney. The thing on this is the law is tricky enough on it and courts are picky enough about the waivers that using an attorney to make sure that they were properly drafted is really important. And look, I know nobody wants to go to an attorney and pay money up front for anything. But I promise on the back end, if one of these waivers can be a solid defense to get you dismissed out of a lawsuit, it will save you so much money in the long run that it's worth it. A couple other things on the cost side of things. First of all, if you use an attorney who does a lot of these waivers, they probably already have a form that they start from. So they've kind of got a running start. They'll just kind of tailor that to your specific situation. And that should mean that as far as hourly bill goes, the cost shouldn't be super astronomical to get a waiver. The other thing I'll say is the law on this doesn't change all that often. And so you could probably get one of these waivers and just use the same one for the next 5, 10, 20 years. It's not something that you would necessarily have to go see the attorney about every year. So if you think about it kind of on a per year cost, that may make it a little bit easier to stomach that lawyer fee that you would be looking at. Okay, we said that courts will enforce these waivers if they're properly drafted. Under Texas law, the 2 main things courts look at is the waiver needs to be express and it needs to be conspicuous. So an express waiver, in Texas, waivers have to actually say the words, we release claims against the landowner for negligence, or we agree not to bring a suit against the landowner for negligence. It has to say those words. If it just said something like, we agree not to sue the landowner, that's not going to be enforceable because of this thing called the express negligence doctrine. That also requires that you want to have the waiver signed at or near the time of injury. There's no case law on what that means. I'll just tell you my gut, and what I do is we get those signed once a year. So for example, if we've got deer hunters that are going to come every November, they sign a new waiver each time they come to hunt. So that's just what I do. The second part requirement for a valid liability waiver is it has to be conspicuous. That means don't hide this in the fine print somewhere on page 5 of your hunting lease. Okay, this needs to be a separate sheet of paper, big bold letters for the title that says liability waiver or release of liability. What you don't want is for the plaintiff to claim that they didn't know what they were signing. And that's an argument that gets made frequently in legal issues related to liability waivers. So that's something to keep an eye on as well. Okay, the next topic I want to discuss is dealing with limited liability statutes. So there are 3 statutes in Texas law that actually offer limited liability to agricultural landowners or animal owners in certain instances. Essentially, what this does is shift the law with regard to liability in favor of ag landowners and animal owners, like say if certain requirements are met. These statutes are great for rural Texas landowners because they do offer you that protection. And as you'll see in a minute, complying with them is relatively easy. It's super inexpensive. And it's just a really good idea. So you want to make sure you look at these limited liability statutes. We're going to talk about the first 2 today, the Texas Recreational Use Statute and the Texas Agritourism Act. We don't have time to get into the Texas Farm Animal Liability Act, but that may be something you want to follow up on later. I at least want you to know that it exists. It's focused more on injuries related to livestock and equine activities, not so much injuries related to other activities on the land. Okay, the first statute we're going to take a look at is called the Texas Recreational Use Statute. This is my favorite one. And the summary of this statute is as follows. So this statute basically says that Texas landowners or other operators, even tenants, right? So if you're leasing land from somebody, it can protect you as well. They're liable only for intentional acts or gross negligence if they meet 3 statutory requirements. So let me just back up for a second. In general, when someone gets sued, a lot of times the claim you'll see made is negligence. Or when you're dealing with land, a lot of times it's a premises liability claim. This basically says the only way that a landowner or tenant or occupier of land can be liable under the recreational use statute is if a plaintiff can prove that that person acted intentionally or with gross negligence. That's a much higher legal standard for a plaintiff to prove. In other words, much more difficult for a plaintiff to prove this and win against a landowner. Intentional acts, and I think we understand that, right? If you intentionally injure somebody, you can be liable. Gross negligence has to be something that's really, really egregious. Cases sometimes talk about how it has to shock the conscience or show a conscious disregard for human life. So again, very landowner-friendly standard that's given to you if you meet the 3 requirements of the statute. The first requirement is you need to have agricultural land. Now, pieces of this statute apply to non-agricultural land. We're not going to get into that today since we're really focused on ag land. So first requirement, you need agricultural land. That's defined as land that is suitable for growing crops, forestry, or raising livestock. Suitable for, you don't have to be doing one of those things, okay? And I don't care what the appraisal district says, all right? So you just need to think about, is my land suitable for one of those activities? I always tell people, think about goats, right? Goats can live anywhere. So if you're suitable for goats, if so, I think you've got an argument that it meets that first prong of the required elements. So if agricultural land, the plaintiff had to be there for a recreational purpose. So in other words, the person who was injured had to be there for a recreational purpose. So that's going to be, there's a whole list, things like hunting, fishing, hiking, biking, riding 4-wheelers, swimming, picnicking, nature photography, and at the end it says, and anything else associated with enjoying nature or the outdoors. So again, very broad definition. If your plaintiff is injured during a recreational activity, the statute potentially can apply to protect you. One thing I will note here, even though that's really broadly drafted, there is at least one appellate court in Texas that has said it does not apply if a attendee at an outdoor wedding is injured. So think if you are somebody who owns like a wedding barn on agricultural land, if someone who was there to attend the wedding gets hurt, courts have said that's not a recreational activity. Whereas if you owned, ranch and someone came hunting and got hurt, that would be a recreational activity. Okay, so again, three-part test: agricultural land, plaintiff's there for a recreational purpose, and then the landowner needs to prove one of the next three monetary requirements. So you'll see here there's gold bullets, and there's three of them listed. If you can satisfy any one of these three, the statute applies, and you get that added liability protection. So the first option is if you don't charge a fee. Right, so if I am an agricultural landowner, I let my neighbor come hunt hogs for free, the statute applies, right? I've met all three requirements, and now I am only liable for intentional acts or gross negligence, right? That's a great option. So if you're somebody who wants to let folks come on your agricultural property for free, for recreational purposes, this is one way to sort of give you the peace of mind to do that. And that was really the intent of the legislature in passing the statute. The second option is if the total charges collected over the past calendar year from recreational uses is not more than 20 times the total amount of ad valorem taxes imposed on the premises for the past calendar year. In plain English, what that means is you need to add up the entire amount of income you made in 2019 from recreational users on your property. Anybody that paid you to hunt, fish, whatever, get a total. Then you need to add up all the property taxes you paid anywhere in Texas, not just the property where you might have hunters or bird watchers, okay? Any property taxes you pay in Texas, including if you got a big house in Austin, get a total. As long as the income from the recreational uses is not more than 20 times higher the property taxes you paid, the statute applies. And most people fit there. You've got to make a lot of money for that not to work. Okay? The third option is one we've mentioned earlier, and that is if you carry liability coverage of at least $500,000 a person, $1 million per occurrence, and $100,000 of property damage. If you carry that level of insurance or higher, the statute applies. We don't care how much you charge. And additionally, you get a cap on your damages at your insurance coverage level, which is why I said earlier, right? If you're going to have recreational users, you want to at least have that amount of insurance because of this statute. Okay, that's the entire recreational use statute. There's no exceptions. You don't have to hang up any signs. If you meet these requirements, it just applies, and you're only liable for intentional acts or gross negligence. Let's look now at the Texas Agritourism Act. Here's my kids at the pumpkin patch that I mentioned earlier. The Agritourism Act is newer, and in a lot of ways it may overlap some with the recreational use statute, but it's a separate defense, so just another piece of paper in that folder that we talked about. And what the Agritourism Act says is that agritourism entities are not liable if the plaintiff is there for a recreational or educational purpose, and the owner either puts up a sign or gets certain release language signed from the plaintiff. All right, so let's break those down. So the first thing, an agritourism entity is not liable. That's defined as a person engaged in providing an educational or recreational activity on agricultural land, regardless of compensation. So this doesn't just apply to pumpkin patches or corn mazes, right? If you own agricultural land and you're providing some sort of recreational or educational activity, this statute applies to you, okay? A recreational activity has the exact same definition of that recreational use statute. So it's very broad. This statute's even broader because it also says it applies to educational activities. So let's say that the county extension agent wants to come out and host a field day on your property. Maybe that is or isn't recreational, we could argue about that, but it's certainly educational, and that would fall under the Texas Agritourism Act. There's one extra step here though. If you're going to try to qualify under this statute, you do have to either hang up a sign or get an Agritourism Act release signed. The sign just has to be hung up at a clearly visible location on or near the premises where the activity is conducted. This is the language, copied and pasted it from the statutes. You can buy these at a number of places, have them, including the Texas Wildlife Association sells these signs. Super cheap way to get some extra liability protection. The other option, you can either hang up a sign or you can get the plaintiffs to sign a release. That release has to be signed before the agritourism activity. It needs to be signed by the participant or their parent, guardian, or managing conservator. It needs to be separate than any other agreement. So don't put this in your hunting lease, separate sheet of paper. And it has to be printed in not less than 10-point bold font. It's in the statute. I don't know. Okay, and here's the language again, copied and pasted it from the statutes. You can just have folks sign that waiver. As far as choosing between the two, there's benefits to both. The sign I like because you can hang it up and forget about it. You don't have to chase people down to make them sign your waiver. The one place I like the waiver better is if you're going to have a minor child on the property. Remember earlier we said that those standard liability waivers may not apply to minor children that are injured. But if you'll look at the second bullet point on this slide, this statute specifically says it can be signed by the parent, guardian, or managing conservator. That looks like pretty good evidence to me that the Texas legislature intended for this statute specifically to allow waiving claims for minor children. Now, there have been no court cases on that. It's a relatively new statute, but I think this is one of your best bets to enforce a waiver against a minor. So if I had anybody under 18 coming, I would make sure and get a waiver, this type of waiver from their parent. Okay, there's a list of exceptions to the Agritourism Act. There's no case law on any of these yet. What I would tell you is let the lawyers fight about the exceptions. It's worth it to you to hang up the sign or get the release and let this be an option in your folder. Okay, the last thing that we're going to talk about, we only have a few minutes left, is a case that just came out of the Texas Supreme Court this year called Hillis versus McCall. I'm going to hit very much on the high notes and give you a high-level summary here. If you want to read more about this or read the entire opinion yourself, you can find that on my Texas Agricultural Law blog website. I'm going to give you that information just in a couple of minutes. So in this case, what happened is you had a landowner that owned a property in central Texas that had a couple of cabins on it. The tenant that lived in one cabin would help out the landowner by going on weekends and opening up the second cabin and getting it ready for guests who came to hunt. And they would kind of lease that out to other guests. One day when the tenant was over opening up that cabin, he got bit by a brown recluse spider when he was reaching under the sink. The tenant filed a premises liability lawsuit against the landowner, right? So he's suing the landowner for his damages, claiming that the landowner violated a duty owed to him. The landowner sought to dismiss the lawsuit. He argued that he did not have any knowledge of spiders on the property or in the house, and that Texas law says generally that landowners are not liable for injuries caused by wild animals. Let's look real quick at the basic law about wild animals, because this is really important and I get a lot of questions on it. The first thing is, in general, the duty that a landowner has to someone on their property really depends on the category of person who's going to be on the property. And we don't have time to get into the details here. But in this scenario, when you had a tenant there who had permission to be there and he was there helping out the landowner, right? The landowner had a duty to warn or make safe dangerous conditions known to the landowner, or which the landowner would be expected to know about with a reasonable inspection. However, with regard to wild animals, there's a couple of exceptions to that rule. And what the law says is a doctrine called Freire Nature, which says a landowner is generally not liable if someone's injured by a wild animal on the property unless the landowner introduced that animal, right? So if you go on vacation somewhere and bring home some crazy snake and put him on the property, you can be liable for him if he bites someone. But if you had hunters on your land and they just got bit by a snake that was naturally there, landowner not liable. Okay, that's a general rule, not liable for wild animals. Unless you introduce them, you reduce them to your possession. So if you went out on your property and like gathered up all the snakes and put them in your snake den that you built, now potentially you're going to be liable for that. If they're just free range snakes, no liability. And then the third exception, which was the one at issue in this case, is inside an artificial structure, which right here we were inside the hunting cabin. If the landowner knew or should have known of the wild animal and could not expect the plaintiff to know, then you can be liable. So what the court ended up doing in the Hillis versus McCall case is they dismissed it. In other words, they sided with the landowner, said, plaintiff, you do not have a case for damages. And the reasons were that there was no evidence the landowner had any specific knowledge of the venomous spiders on the property. There was also no evidence that the landowner had any more knowledge than the plaintiff. In other words, the plaintiff could have seen the spider just like the landowner. And so this case was dismissed in favor of the landowner. Keep in mind again, the landowner won. The case got dismissed, right? The plaintiff didn't take any money, but the landowner had to pay all those legal fees to get himself out, go through trial and appeals in the Supreme Court to win. That's why that liability insurance is so important. And hopefully for that landowner, it was his insurance company paying those fees rather than the landowner paying them out of pocket. Okay, so just to wrap it up, a couple of things. If you're interested in agricultural law, we've got a number of programs coming up this fall around the state. Hopefully those will be in person. The first group of programs is called Owning a Piece of Texas. It's just an all-day ag law program where we talk about the key agricultural laws that landowners need to know. You'll see the dates there. We also have a rancher's leasing workshop. I apologize that that says 2019. Those are the 2020 dates. We had to do some juggling to reschedule those because of COVID. But you'll see the dates there. That's a half-day program that really focuses in depth on grazing, hunting, and livestock leases. That program, the Rancher's Leasing Workshop, is also available as an online course that you can take from the comfort of your home at any time. If you're interested in that, contact me. Okay, the last couple of slides. This is my website that I mentioned, the Texas Agriculture Law blog. If you're interested in ag law, I would encourage you to check it out. You can subscribe when a little box pops up if you'll put your email address. All my posts will go to you every time I do one. So when a new case comes out or if I write a new handbook, that's where you can find that type of information. I also have my website, my podcast. It's called Ag Law in the Field. If you're a podcast listener, we're on iTunes, podcast app, Google Play, Stitcher, anywhere you listen to your podcasts. If you have no idea what I'm talking about, all you need to do is at the top of this slide here, you'll see it's aglaw.libsyn.com. If you will type that into your computer, what you're going to find is a list of about 80 interviews I've done with different ag lawyers on different topics. They're audio only. You can just scroll down. If you see a topic you're interested in, push play. And those, you can just listen to my interview with those attorneys. It's free, it's easy. Feel free to check that out. The last slide here has all of my contact info. Like I said at the beginning, if you all have questions or if you need more information, please feel free to reach out by email, by phone. I'm on social media, Twitter and Facebook, so I'd sure be glad to answer any questions you may have, and I really appreciate your time today.